Let's get going then. Good morning, everyone. The reason why we're holding this press conference today is to bring to the attention of the public the extraordinary, arbitrary, and without ample notice by the Minister of Health and Long-Term Care of Ontario on the recommendation of the Transitional Council of the College of Traditional Chinese Medicine, Practitioners and Acupuncturists of Ontario of Regulation 2713, which requires practitioners to register on or before April the 1st, 2013, but the registration was closed on March the 19th, 2013. The regulation was considered and signed by the Minister and passed early this year on January the 25th, 2013, but not brought to the notice of the practitioners until the middle of February and not until March the 1st, as I'm advised by telephone from a number of practitioners. Apart from the impossibility of many to register, those who cannot will lose their license as of April the 1st, 2013. Their patients will be unable to access them for treatment, and the insurance policies which govern their practices and allow for the clients to be indemnified for services will be cancelled. So as you can appreciate, for those who wanted to register, they had about 6 weeks' notice. The registration also required them to pass and study 2 exams, one called the Safety Handbook and the other one called the Jurisprudence Handbook. And each of these 2 handbooks contain about 150 pages of materials, all written in English language, although what we're dealing with here is the practice of traditional Chinese medicine and acupuncture. The Transitional College's bylaws and its regulations require the applicant to speak, write, and read reasonably in the English language. Unfortunately, reasonably is defined subjectively by the examiner, and it does not account for those applicants who may be heavily accented in the Chinese language. One has to recognize that the practice of traditional Chinese medicine, the key criterion is the Chinese language, and fortunately, we have British Columbia as an example for more than 7 years where the practice allows for bilingualism. When I say bilingualism, please take into account I'm not referring to English and French. I'm referring to English and Chinese. I see a little smile from my CBC reporter here. So when we say bilingualism, I mean English and Chinese, and that was because in British Columbia it recognized that the profession is essentially a Chinese cultural creation which has completely different hypotheses and beliefs than the Western medicine. It is apparently the belief of the British Columbia government that the cultural identity of the Chinese be recognized, its traditions, teachings, and beliefs be at least recorded. As such, the Chinese language is the integral component for the sake of the safety of the practitioners and the safety of British Columbia, people of British Columbia. It should also be recognized when the recommendation was made for the regulation of TCM, traditional Chinese medicine, that British Columbia be used as a precedent and to follow that model. The failure of our minister to recognize this and to treat this cultural difference in a manner that the way the current regulations is being passed amounts to discrimination on the basis of race, which is contrary to the Charter of Rights and Freedom. The other issue that must be recognized is that TCM practitioners are not against regulation. They are in favor of regulation. So the issue here is not why. The issue is how and what is being regulated. The main counsel on this file, Mr. Cecil Rotenberg, is in fact in court trying to seek a date to hear the interim injunction to stop the regulations from taking into effect on April the 1st. Mr. Rotenberg advises he is on his way back, depending on how long he'll have to park on the Don Valley, but if the valley is moving, he'll be here probably in 20 minutes. However, he's advised that the court has adjourned the matter to the 30th of May, 2013, to hear the interim injunction, and it will be heard by one judge. So, interestingly, the issue then becomes between now and May the 30th, what would be the status of the practitioners who are not registered with the Transitional Council. That is up in the air, and we are not sure how that will play out in the interim. What you have is I've provided you a package of materials which includes the affidavit of Dr. Lee and also the position of the Federation. It's important to note that the Transitional Council that was set up has issues and concerns in that the members that constitutes the council, their qualifications are problematic and questionable, and the fact that this council may suffer from arbitrariness and bias towards the practitioners is an issue that we wish the court to hear and for the minister to hear. And for these reasons, the Federation, which represents about 2,000 practitioners and treating about 1 million patients, is seeking an injunction to prevent the hasty and abrupt passage of the regulation to take effect on April the 1st. I wish to just point out that the economics of more than 1,500 to 2,000 members are affected with the right of about 1 million patients to choose their own practitioners. We agreed that non-qualified persons should be weeded out and restrained from practice, but a regulation on the basis of speaking, reading, and writing English reasonably does not provide that balance between recognition and safety that is guaranteed by our Canadian Charter of Rights and Freedom. Thank you. What I'm going to do is now invite Dr. Lee to come and speak a few words on behalf of the Federation.
Can we give you a couple of questions first?
I prefer that Dr. Lee provide you with a few comments, and if Mr. Rotenberg is here, to wait for questioning with Mr. Rotenberg. Okay, thank you.
Can you give me the press?
Good morning, everyone, ladies and gentlemen, media and friends. Glad to see everyone here. Today, I am speaking on behalf of Federation of Ontario Traditional Chinese Medicine Associations. As we just heard from our legal counsel, we retain a legal team to start a litigation against the Ontario Regulation 2713, which we think is manifestly unfair for our practitioners and also unfair for the public safety and patient's choice. So let me make this first very clear. All our members in our federation fully support a regulation on Chinese medicine and acupuncture to standardize our practice, to make a safer choice for the patient is always our first priority. But the problem lays on how this regulation lay out. The council was first appointed in 2008. From the very beginning, our federation have contacted the Ministry of Health concerning their qualifications and the way of conducting their business. And all those concerns, all those communication seems to be fell on the deaf ear. So all those years, the council been doing things according to their own wills. The fundamental part of any health regulation is the listening to the voices from the practitioners, whether it's a medical, whether it's a nurses, whether it's dentistry, or even engineers or lawyers, whoever is a profession in this province is always be self-regulated. That's the fundamental for all the regulations. So we're supposed to come up with a collective ideas among the practitioners and with consultation with the public. Then these ideas will come up a package given to the council, and the council will submit to the Ministry of Health. It was not done like this way, so that was not received very well from the public and also from our practitioners. So that's why you can see why there's so much of this kind of a disagreement. It's not we not want any regulations. We really want the public have a safe choice, but we're also seeing the Chinese medicine being practiced for so long. Not to mention, it's been over 2,000-3,000 years practiced in China, in other countries of Asia, but even in Canada, the Chinese medicine is being safely practiced over 100 years. So many of the patients get great benefits from our treatments. The service from acupuncture and traditional Chinese medicine give a great complement to our healthcare system. We do not use any dollars from the government, doesn't cost the public health service any fees at all. So entirely give the patients a freedom of choice. So based on this, there's absolutely no reason any kind of regulation will suppress our practice, and it doesn't go well with the multicultural policy in Canada. So this is what we want ask the court to hear our stories, because the current government seems no interest to listen towards the people's voice. So that's one important thing we want to mention here. So, and there's a number of things they actually lay down in these regulations. For example, they say no practitioner can sell any products to a patient with a profit. So that seems to be very similar to what the medical doctor do. So that's one of the fundamental issue here. The regulation of Chinese medicine should not be as identical as a biomedical medicine. This is two totally different medical systems. So to imply or to try to unilaterally utilize a regulation that seems to be well done in the medical field, just making this on the Chinese medicine is not going to work well. If you look upon other practitioners, for example, the naturopathic doctors, homeopathy practitioners, and other health practitioners, using the products in their service, it's always a part of the service. And not to saying actually compounding and mixing the traditional herbs is intellectual rights of those practitioners. So to limit that kind of service, it will greatly diminish the value and the service of the Chinese medicine and limits the choices for the public too. And another thing they mentioned in the regulation says, when a service or when there's a condition deemed as necessary for the surgery, then Chinese medicine, acupuncture cannot touch them at all. But we see a lot of patients, whether it's arthritis pain or needing some kind of ease for the back or the knee replacement, the patient have a choice. They say, I do not want to go for a surgery. Do you have an answer? I heard there's a lot of patients being receive the treatment from you guys and receive a great benefits. So under their proposed regulation, which is approved by our health minister, that kind of service will be deemed illegal. So that's manifestly unfair to both practitioners and the patients. So that's a few things I want to say that. And also at the end, I want to mention the council itself. We've been complaining to various departments of the Ontario government saying whoever sits on the council need to be reputable, need to stand up in front of the public. Their credentials, their ethics must be right. 3 out of the current council's professional members have questionable qualifications. One of them actually claimed he is an acupuncturist, traditional Chinese medicine practitioner. At the same time, we find out, never disclosed by himself, he is a registered massage therapist. It's contrary to the Traditional Chinese Medicine Act. It says very clearly under RHPA, Regulated Health Profession Act, any member sits on a council in a regulated college cannot be a member of another health regulated profession. So why this government actually appoint persons they know actually will contrary their own law? 2 more members. One was a member, used to be the president of the council. Another is the current chair of this council. They claim they have a PhD from an Asian country, from Sri Lanka. Their qualification is very, very questionable. We really want to see where do they get this qualification from. If they say they have the highest standards of the degrees, it's supposed to be exposed to the questions and make sure that's all real. So that's a few things I want to say, and thank you for your attention.